Hello, my name is Donald Dare. I'm the Chief Executive Officer of the Pan-African Lawyers Union, PALU. I also chair the steering committee of the Pan-African Citizens Network, PASSIN, and I serve on the steering committee of the Coalition for an Effective African Court on Human and People's Rights. The topic we will discuss today is the use of the African human rights system for human rights advocacy, especially around areas of freedom of information, the right to information, and associated rights. And I'd just like to say that indeed we are seeing an upsurge in the use of African human rights system organs and institutions, both at the continental level and at the regional level. We're seeing African citizens, African activists, African civil society organizations, trade unions, and so on, relying more on this AHRS, as I call them, the African Human Rights System organs and institutions. And at the continental level, we have the African Court on Human and People's Rights, the African Commission on Human and People's Rights, the African Committee of Experts on the Rights and Welfare of the Child. And at the sub-regional level, or the regional level as we call it in Africa, we've got the courts of the regional economic communities, such as the East African Court of Justice in Eastern Africa, the Community Court of Justice of the Economic Community of the West African States, that's ECOWAS Court. In Central Africa, we've got the CEMAC Court, the Court of the Common Economic and Monetary Union of the Central African States, which is quite a bit active. And in the Southern African region, we've got the SADC Tribunal, the Tribunal of the Southern African Development Community. So one could ask why. Why is there this upsurge in use of these institutions? And it could be for several reasons. One, at the AU level and at the regional level, over the last 20 years, we've seen the passing of very strong norms that provide for democracy, good governance, rule of law, human and people's rights, and so on. So we've seen the AU, for instance, in the period between 2000 and 2010, passed at least 15 new legal instruments that touch on one aspect or the other of democracy. We had the passing of the Constitutive Act, which ushered in a new way of doing business at the AU, moving away from non-interference to non-indifference. We had the Protocol on the Rights of Women in Africa. We had the Anti-Corruption Protocol. We had the Charter on Democracy, Elections, and Governance, and so on. So a strong body of laws was formed. But at the same time, we see a move towards Pan-Africanism, that people want to express practical solidarity with each other across borders and across regions. So you'll see, for instance, if there's a case involving Zambia, you'll see colleagues from Mozambique, colleagues from Zimbabwe, and so on interested. If there's a case involving Tanzania, you'll see colleagues from Kenya, from Uganda, from Rwanda, from Burundi, all participating in one way or another in the campaign, including in litigation. So maybe we explore a bit more what we mean by the AHRS and especially focus on the complaints mechanisms. I notice in your documents you refer to them as appeals mechanisms. It's not really an appeal because you're not appealing from a decision that happened at the national level. You're just saying that you're dissatisfied with whatever was the decision made at the national level, and therefore you're taking your complaint to another level. So the African human rights system exists at 3 levels: continental, regional, and national. So we have continental level organs and institutions, we have regional level organs and institutions, we have national level organs and institutions. And of course, the African human rights system also collaborates and cooperates very closely with the global human rights system that's headlined by the UN, the United Nations, especially the Geneva institutions and also the New York institutions. So at the continental level, for purposes of our focus on right to information today, we've got the African Court on Human and People's Rights, which is based in Arusha in Tanzania. We also have the African Commission on Human and People's Rights, which is based in Banjul in the Gambia. At the continental level, to go there, you have to have exhausted local remedies. That means you'll have tried to litigate this matter in your national courts to the highest existing court, and you're still dissatisfied. Then you or any other person can then take up the case at either the African Commission or the African Court, because you can say you'll have exhausted local remedies. There's a rider, though, that sometimes you can say the local remedies were not available or were not efficient. Then that way you don't have to exhaust them. So for instance, if your country's laws provides that the issue you are debating cannot be litigated at the national level, then obviously there's no available local remedy. If other colleagues, either yourself or even other colleagues, have tried to litigate the thing and it has stayed in courts for an unduly long period, you can use that and say that the local remedy is not efficient, or not practically available to you. So what's the difference between the court and the commission? Not much, really. The commission is an older body. You can, in a sense, equate it to a national human rights institution at the national level. It has a promotional mandate to promote human and people's rights and a protective mandate to deal with complaints. And it has dealt with complaints. And when it finishes dealing with the complaints, specific complaints against a specific country, it issues a decision known as a communication. So there are those that feel that the communication sounds more like advice or a recommendation to the state. I think it has more weight than that in international law. But at any rate, the difference between the commission and the court is the court then issues a binding decision. The court is a new institution created long after the commission, which issues binding decisions. Now, of the 55 African countries, 54 of them have signed and ratified the African Charter on Human and People's Rights and are therefore bound by the Commission, and you can take your complaints to the Commission in Banjul. But as for the court, of these 55 countries, 30 have ratified the protocol establishing the court and are therefore bound by the court. But in total, only 10 had made the additional declaration that allows citizens to sue them directly. And subsequently, of these 10, 4 have revoked that declaration. And that is Rwanda, Tanzania, Cote d'Ivoire, and Benin. So for only in respect of 6, Burkina Faso, Malawi, Ghana, and 3 others, can you sue directly. If you can't sue directly, that means if you have a complaint, you take the complaint, for instance, to the commission, and then you ask the commission that rather than hear the matter itself, it brings the case to the court, and then now at the court it's the commission that will be the complainant, and you'll be the interested party. So that's the court and the commission at the continental level. At the regional level, we have at the moment 2 very active courts. That's the East African Court of Justice for the 6 East African community states, and the ECOWAS Community Court of Justice. That's for the 14 states of the ECOWAS region. The CEMAC Court, the Court of the Economic and Monetary Union of Central Africa, is also a bit active, not as active as these 2. And there's also the SADC Tribunal, which had begun being quite active about 14 years ago, 12 years ago. Then the member states, the governments of the SADC countries, then revised the protocol of the court and said citizens cannot sue directly and only states can sue each other. So one major difference, barring that problem with the SADC Tribunal, one major difference with the regional courts is there's no requirement of exhaustion of local remedies. So you don't have to file a case at the national level first and exhaust it. You can choose to do so and then come to the sub-regional level, or you can just choose to come to the sub-regional level directly. These were courts that were created for regional integration, but they were also integrating principles and values. So they're very strong on integrating principles of democracy, good governance, rule of law, gender equality, human and people's rights, including the right to information and the right to freedom of expression. So all these courts are forums that you can choose to go either to the regional court or to the continental court when you feel there's an issue that you need to tackle. In terms of implementation of their decisions, we found that the governments have not been very active yet in implementation of their decisions. But these courts themselves have in the last couple of years been taking measures to more directly supervise decisions that they make, and also political organs of the AU have been taking measures to try and ensure that decisions are implemented. And we, as the citizens, as activists, as civil society, as bar associations and law societies, can also do more to push our governments to implement. Thank you.